इनके खिलाफ क्या मैं बता रहा हूँ,
हाँ,
इन्होंने ऑर्डर शीट में लिखा कि जजमेंट प्रोनाउंस, जजमेंट प्रोनाउंस नहीं किया। एक्सप्लेनेशन कॉल किया गया जब ये कंप्लेंट की किसी पक्षकार ने कि जजमेंट नहीं मिला, तो डीजे ने एक्सप्लेनेशन कॉल किया। इनका एक्सप्लेनेशन ये था कि इमीडिएटली विंटर वेकेशन लग गया था, मैं छुट्टी में चली गई। विंटर वेकेशन के आके 10 दिन बाद भी वो जजमेंट फाइल में नहीं है। इसमें क्या रिपोर्ट आई? एडीपीओ ने कंप्लेंट किया कि कंप्रोमाइज के बेसिस पर केस खत्म हुआ, इन्होंने कंप्रोमाइज ना लिख के मेरे हाजिरी में प्रोसिक्यूशन एविडेंस नहीं देना चाहता।
Yes. Who has to argue now?
Your Lordship, Mr. Bharat is just coming.
Yes.
And Your Lordship on the last date has called for the records also.
Yes.
So they got the records.
Yes. What was the record?
Your Lordship was anxious to know about the proceedings which were placed before the standing committee. And apart from that, regarding the CR, etc. Your Lordship. The parameters, please. Lordship, the committee had resolved not to extend the probation of the petitioner herein, and the material which was placed before the committee, along with the all judicial officers, had provided summary regarding the performance and the.
What was the question put by me on the last date of hearing? What was the material you have collected to record opinion?
Lordship.
I want to see the opinion material.
Lordship.
What was the material collected by the High Court and placed before the committee?
Lordship.
Please tell us.
Lordship.
Yes,
Mr. Bharat is coming.
yes.
Yeah.
Let him come. No problem. Yes, Mr.
Sorry, recording.
I had got the records.
Yes.
Can
पता ही नहीं क्या लिखा आपने, पहले एक बार बता दीजिए ओरली तो हमको थोड़ा सा दिमाग में बैठ जाएगा.
The consideration was taken for 10 persons. And after taking into consideration their service record, decision was taken to confirm 9 of the employees.
Yes, what is the record you have received?
Yes, yes. So far as 9 persons are concerned, 10 persons are concerned, what has been considered their ACR and the complaints received by them and the comments made by the reporting authority. So far as the other persons are concerned, there were no complaints against them. One of the officers, he received D, he had also received D. in ACR. But since there was no complaint against her, was not taken, she was confirmed. The reporting authority had made also certain communication. So I had got the entire record which was placed before the committee, standing committee. Also is there.
बताइए.
वो भी दिखा देंगे बाद में. It contains all the 10 persons whose case was placed before the standing committee.
And what about the particular the petitioner is concerned?
I had flagged it also.
Yes.
Lordship, in the next bunch, Lordship.
Next,
This is white.
it is in the next bunch, white. In white bench, I had flagged it.
Yes. It is a complete record, na? Complete record.
There were some complaints.
Yes.
By the ADPO, by some of the other members of the bar, some litigants. So they were not taken into consideration. What I want to submit that it was not based on a misconduct. It was a routine confirmation. And during that routine confirmation, it was found that despite opportunities, he had not approved her standard. The reporting authority had given the comments. Complaints were there. So without taking into consideration the complaints, a decision was taken that he should not be confirmed. As many as 5 complaints were there. And also the comments of the reporting authority. So far as the other officers are concerned, one of the officer, there was a complaint against her. Affidavit was called from the complainant. Despite 3 reminders, complainant had not turned up. So it was placed before the portfolio judge. And other officers, there were no complaints. So I had also enclosed the complaints.
Yes.
Against one of the officer, in whose case the affidavit was not filed by the complainant despite reminder, and all the 5 complaints of her.
These complaints were supported by affidavit.
Yes. Explanation was sought by also.
Yes.
But the decision was not taken from those complaints. So it was the complaints were not the basis. The overall performance was the basis for not extending or confirming the probation.
So what are the parameters you have?
The parameters were the ACR and the conduct. These are the 2 parameters. ACR, admittedly, she got D. There was one other officer who also got D. But there were no complaint. The reporting authority had not given any adverse. So far as ACR is concerned, it is based on the basis of evaluation of work done by the officer. Certain marks are prescribed for civil cases, criminal cases, etc., etc. So it was found to be below the average. The document which she had filed along with the writ petition is for the year 15-16, which was not taken into consideration because 15-16 ACR was not communicated to any of the officers. So far as 14-15 is concerned, it was below average. So if Lordship comes to her case, I had flagged it. The comments of the reporting officer, we had annexed it. And on the basis of which the decision was taken not to continue or to confirm. There is fortunately I got one of the judgment of the identical facts that is reported in 2021, volume 13, SCC, page 151.
2021,
volume 13, SCC, page 151. 151. It is of Rajasthan High Court.
Yes.
Identical situation. On the other hand, this case was on a better footing. In that case, the
3 judges judgment hai?
Huh?
I think 3 judges judgment hai.
Yes. In that case, the officer was having all the ACRs as good. Even then, the Supreme Court has said that getting an ACR as good would not qualify to be confirmed. That the officer cannot claim that since his ACRs are found to be good, so he is entitled for confirmation. All the other factors should to be considered by the High Court. In this case, the High Court had considered the other factors and came to the conclusion that the officer is not fit to be.
So whether the Honorable Supreme Court, while deciding the case, has given some guidelines, what should be the parameters to be considered?
No, in this case, the parameters has not been given.
Yes.
But the two issues has been considered. The first issue, that if the ACRs are good, can it become an indivisible right to a candidate to get it confirmed? Number two, if the other factors which were taken into consideration are not the basis of not continuing the confirmation or dismissal, then the court should not interfere. In this case, on the administrative side, the officer was terminated. He filed a writ petition. He, along with other persons, filed a writ petition. The Rajasthan High Court has allowed the writ petition on the ground that the principles of natural justice has been violated. There is no non-compliance of Article 311. But during the hearing before the Honorable Supreme Court came to the conclusion that since it was a case of routine confirmation, the prescriptions of 311 would not be attracted. The prescriptions of 311 would be attracted only if that is the foundation of that dismissal is some misconduct. So, paragraph 2 of this judgment is entirely similar to her. Shall I read paragraph?
Yes.
Paragraph 3. Certain allegation of misdemeanor and corruption in discharge of judicial functions were received during the probation period against few of the judicial officers, including
Mr. Bharat, एक चीज बताइए. The question of corruption and question of corruption and question of misbehavior, or where you have recorded a finding, the integrity.
It is not required. That is why I am reading this judgment.
Yes.
It is not required.
Please read it. Please.
I am reading this portion just to give the background of the case before the Rajasthan.
Yes.
Certain allegation of misdemeanor and corruption in discharge of judicial functions were received during the probation period against a few judicial officers, including Respondent 1, on the basis of which the Registrar Vigilance called for the records and submitted a report dated such and such. This report was put forth before the Administrative Committee of the High Court along with a wealth of other material while it was undertaking the confirmation process of over 93 probationer judges. This 5 judges committee sought to determine the suitability of the probationer as per terms and condition of appointment by evaluating their integrity, knowledge, conduct and behavior. In this process, the committee relied upon numerous material including reports submitted by the district judges, inspecting judges, ACR as well as the aforementioned reports submitted by the Registrar Vigilance. After due consideration, it was recommended that the services of 90 officers be confirmed, the probationary period of 1 officer be extended, and service of 2 judicial officers, including Respondent 1, not to be confirmed.
Mr. ये आपके रूल्स में कितने बार प्रोबेशन कर सकते हैं एक्सटेंशन?
ऐसा उसमें कुछ नहीं लिखा है.
There is no limitation.
उसमें सिर्फ ये है कि until confirmed.
हाँ, पर whether the full court can extend the probation period?
It was extended for one time. It was extended in the case of the petitioner.
Yeah,
In the case of petitioner and two other officers.
Yes. One time
it was extended.
Extended.
It was extended. I had placed that record also.
Yes.
This report was placed before the full court of the High Court, which on 1694 confirmed the recommendation. Consequently, on the recommendation of High Court, the state government wide order dated such and such dispensed with the services of the respondent 1. Now,
when the promotion period was extended?
वो रिकॉर्ड आपके पास है?
Yes.
एक बार बढ़ाया 3 लोगों का।
बताइए।
नहीं है। कोर्ट इन्होंने लगाया है अपनी रिट पिटीशन में। ये पेज 55 अनेक्स है। कब का डेट बताओ? 18 मार्च 16 18 मार्च का फुल कोर्ट की और 18 मार्च को एक्सटेंड हुआ है। ये फुल कोर्ट की मीटिंग का ये है। और पेज 55 of the writ petition,
yes.
Annexure P9 is the order 18 March
for extension.
For extension.
And this was extension for one year.
Yes.
And after
the period has not been mentioned.
Yes.
Rule simply says until the order of confirmation is not issued, there would be probation.
Remain in
automatic confirmation.
Confirmation is not.
Nahi.
So this is your submission. This is your submission.
Yes. Paragraph 13 of this judgment, Rajasthan High Court judgment.
Yes.
At the outset, we may observe that both the appellant as well as the impugned judgment have elucidated the correct statement of law regarding the width and sweep of judicial review by the High Court over the decision taken by its full court on administrative side. Although it would be a futile task to exhaustively delineate the scope of writ jurisdiction in such matter, but a High Court under Article 226 has a limited scope and it ought to interfere cautiously. The amplitude of such jurisdiction cannot be enlarged to sit as an appellate authority. Hence, care must be taken to not hold another possible interpretation on the same set of material or substitute the court's opinion for that of disciplinary authority. This is especially true given the responsibility of power bestowed upon the High Court. Under Article 235 of the Constitution, the collective wisdom of the full court deserves due respect, weightage and consideration in process of judicial review. The present case is one where the first respondent was a probationer and not a substantive appointee, hence not strictly covered within the umbrella of Article 311. The purpose of such probation has been noted in Qazia Muhammad Muzammil. The court kiya hai, the purpose of
probationer paragraph 19 is the relevant.
The paragraph 14, हाँ 19 तो है ये काजिया मोहम्मद में उन्होंने कोट किया है, उसको उन्होंने रिलाई किया, पैराग्राफ 14. The purpose of any probation is to ensure that before the employee attains the status of a confirmed regular employee, he should satisfactorily perform his duties and function to enable the authorities to pass appropriate order. In other words, the scheme of probation is to judge the ability, suitability and performance of an officer under probation. 15. Similarly, in Rajesh Kumar Shrivastava, it was opined a person is as to whether his service should be continued and that he should be confirmed or he should be released from service. It is thus clear that the entire objective of probation is to provide the employer an opportunity to evaluate the probationer's performance and test his suitability for a particular post. Such an exercise is a necessary part of process of recruitment and must not be treated lightly. Written tests and interviews are only attempts to predict a candidate's possibility of success at a particular job. The true test of suitability is actual performance of duty, which can only be applied after the candidate joins and starts working. Such an exercise undoubtedly is subjective, therefore respondent one's contention that confirmation of probationers must be based only on objective material is far-fetched. Although quantitative parameters are ostensibly fair, but they by themselves are imperfect indicator of future performance. Qualitative assessment and a holistic analysis of non-quantifiable factors are indeed necessary. Merely because respondent one's ACRs were consistently marked good, it cannot be a ground to bestow him with a right to continue in service. Further, there is a subtle yet fundamental difference between termination of probationer and that of confirmed employee. Although it is undisputed that the state cannot act arbitrarily in either case, yet there has to be difference in judicial approach between the two. Whereas in the case of a confirmed employee, the scope of judicial interference would be more expensive given the protection under Article 311 or the service rule, but such may not be true in the case of probationer who are denuded of such protections while working on trial basis. Probationers have no indefeasible right to continue in employment until confirmed, and they can be relieved by the competent authority if applicable. It is only in a very limited category of cases that such probationer can seek protection under the principle of natural justice, say, when they are removed in a manner which prejudices their future prospects in alternate field or cast aspiration on their character or violate their constitutional right. In such a case of stigmatic removal, only that a reasonable
So
opportunity.
probationer can even for re-examination can allow me to participate in the examination again.
Yes, since it was only a termination, it is not a case of dismissal. That is the basic difference between the two. In a case of dismissal, the candidate is precluded to get a opportunity in other services or even in the same services. But so far as a dismissal is concerned, his services are dispensed with that job. In short, if the termination of service is founded on the right flowing from a contract or the service rule, then the termination is not a punishment and carries with it no evil. The rules they terminate to employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank. The government may nevertheless choose to punish the servant if the termination is sought to be founded on misconduct, negligence, inefficiency or other disqualification. Then it is a punishment and the requirement of Article 311 must be complied with. The order termination of services of respondent 1 recites that the Rajasthan High Court, Jodhpur, after examining all the relevant records, has been found of the opinion that Shri Ved Priya has not made sufficient use of his opportunities and otherwise also failed to give satisfaction as a probationer in Rajasthan Judicial Service. It is explicit from these content that neither any specific misconduct has been attributed to respondent 1 nor any allegation was made. The order is based upon overall assessment of the performance of respondent 1 during the period of probation, which was not found satisfactory. Such an inference, which can be a valid foundation to dispense with the service of probationer, does not warrant holding up an inquiry in terms of Article 311. It is thus not true on the part of respondent 1 to allege that it was a case of indictment following allegation of corruption against him. True, it is that the form of an order is not crucial to determine whether it is simpliciter or punitive in nature. An order of termination service, though incautiously worded, may, in the fact and circumstances of a peculiar case, also be aimed to punish the official on probation, and in that case it would be undoubtedly an infraction of Article 311 of the Constitution. The court, in the process of judicial review of such order, can always lift the wheel to find out whether or not the order was meant to visit the probationer with penal consequences. If the court finds that the real motive behind the order was to punish the official, it may always strike down the same for want of reasonable opportunity of being heard. There is nothing on record in the present case to infer that the motivation behind the removal was any allegation. Instead, it was routine confirmation exercise. The evaluation of services rendered during the probationary period was made at the end of first respondent tenure along with 92 others. Vigilance reports were called not just for respondent 1 but also for at least 10 other candidates.
So you have also called the report from vigilance
In that case.
in the present
नहीं, इसमें तो complaints आई, कोई रिपोर्ट नहीं
तो vigilance
वो राजस्थान में विजिलेंस की रिपोर्ट है,
नहीं,
इनके खिलाफ
हमारे
कोई
यहाँ-
करप्शन का चार्ज नहीं है.
no correction nahi hai, but on the basis of the complaint,
हाँ.
if suppose if any complaint is made against anybody and without examining the genuineness, भाई देखिए, the profession
इनके खिलाफ क्या मैं बता रहा हूँ,
हाँ,
इन्होंने ऑर्डर शीट में लिखा कि जजमेंट प्रोनाउंस,
हाँ,
जजमेंट प्रोनाउंस नहीं किया। एक्सप्लेनेशन कॉल किया गया जब ये बात, ये कंप्लेंट की किसी पक्षकार ने कि जजमेंट नहीं मिला, तो रीजन एक्सप्लेनेशन कॉल किया। इनका एक्सप्लेनेशन ये था कि इमीडिएटली विंटर वेकेशन लग गया था, मैं छुट्टी में चली गई। विंटर वेकेशन के आके 10 दिन बाद भी वो जजमेंट फाइल में नहीं है। इसमें क्या रिपोर्ट आई? एडीपीओ ने कंप्लेंट किया कि कंप्रोमाइज के बेसिस पर केस खत्म हुआ, इन्होंने कंप्रोमाइज ना लिख के मेरे हाजिरी में प्रोसिक्यूशन एविडेंस नहीं देना चाहता है। उसका एक्सप्लेनेशन इनका यह है कि वो एडीपीओ को कुछ दिक्कत हो जाएगी, इसलिए मैंने ऐसा लिख दिया।
where that all the documents is in the record.
सब है।
Yes.
Even otherwise, it may not be true that just because there existed on record some allegation of extraneous consideration that the High Court was precluded from terminating the service of Respondent 1 in simpliciter manner while he was in probation. The unsatisfactory performance of a probationer and resultant suspension of service at the end of probation period may not necessarily be impacted by the fact that meanwhile there were some complaints attributing specific misconduct, malfeasance, misbehavior to the probationer. If the genesis of the order of termination of service lies in a specific act of misconduct, regardless of overall satisfactory performance during the probation, the court will be well within its reach to unmask the hidden cause and hold that the simpliciter order of termination, in fact, intends to punish the probationer without establishing the charges by way of an inquiry. However, when the employer does not pick up a specific instance and forms his opinion on the basis of overall performance during the period of probation, the theory of action being punitive in nature will not be attracted. Onus would thus lie in the probationer to prove that the action taken against him was of punitive characteristic. पूरी रिट पिटीशन में एक भी सिर्फ अवरमेंट है कि मैंने एक 2 जजेस के खिलाफ मैंने कंप्लेंट की थी इसलिए लिया। वो दोनों कंप्लेंट जो हाई कोर्ट ने उसको क्लोज कर दिया कि पहले कैप्टन अवेंस रखा, उसको क्लोज कर दिया।
कब क्लोज किया?
बहुत पहले
है रिकॉर्ड?
हाँ, उसमें कोई एक्शन नहीं लिया। इन्होंने अवरमेंट किया कि मैंने 2 के खिलाफ कंप्लेंट किया और वो हो गया।
वेयर दैट रिकॉर्ड की कंप्लेंट क्लोज कर दी हाई कोर्ट ने?
ये
बताइए।
वाला वारियर पर वो शायद लगा भी है पेपर बुक में। है? Page number 401. Investigation, but it was based upon a holistic assessment of the respondent service record, even taking an effect-based approach. We do not feel that the order of non-confirmation or preceding circumstances would prejudice the respondent meriting a higher procedure required. तो इनका तो केस इनसे अच्छा था, उसमें सुप्रीम कोर्ट ने बोला कि मेयरली गुड है तो नहीं होगा, ओवरऑल परफॉर्मेंस उसमें वेरीफाई करना होगा। इसमें भी एक बार एक्सटेंशन मिला था, इनके केस में भी एक बार इनको एक्सटेंशन मिला और उस एक्सटेंशन में कुछ नहीं हुआ। इन्होंने कुछ अपने एसीआर्स लगाए हैं, लेकिन वो एसीआर्स हैं 15-16 के। जो पीरियड था इनका कंफर्मेशन का 14-15 था, जो टेकन इनटू कंसिडरेशन, क्योंकि 15-16 का एसीआर तो कम्युनिकेट किसी को नहीं। 14-15 का अगर एसीआर भी मैं लाया हूं, अगर उसको देखेंगे शी वॉज बिलो एवरेज, वो भी दे शी वॉज बिलो।
यस,
there is a basic difference between termination and
yes, that is the issue which
on the last date of hearing I had referred that Mahanadi Courtfield judgment,
yes,
in which all the previous judgment has been taken into consideration, and thereafter the court came to the conclusion that this is the difference, that in termination the candidate is free to get an opportunity of employment in some other sources or even in the same source.
Yes.
But so far as dismissal is concerned, since it is an stigmatic, the candidate is precluded to get an opportunity.
And what was the power given to the standing committee?
The power is given to the standing committee is to give a decision other than dismissal. Termination word is there, other than dismissal. So the standing committee has not resolved that her services should be dismissed. The standing committee had resolved simply to terminate his services. So standing committee was having the judgment.
So you want to say that the word used in the rules 4C of the rules, the word is to be understood.
Word is used other than dismissal.
Other than dismissal. And other than dismissal, whether when he was discontinued or probationary period, whether it has can you give one law on this issue? Whether even if he has been probationer has been not extended, probation period has not been extended, it will not amount to termination.
ये राजस्थान का जजमेंट यही है.
He doesn't deal with the particular this question which I want to put you, Bharat. Whether the probation, if not extended, will amount to dismissal or termination.
वो तो 311 के स्कोप से बाहर हो गया ना.
Where it has been
311 का स्कोप इसमें रेफर किया है राजस्थान वाले जजमेंट.
Yes, बताइए वो बीच पैराग्राफ.
Paragraph 14.
Yes.
The present case is one where the first respondent was a probationer and not a substantive appointee, hence not strictly covered within the umbrella of Article 311. The purpose of such probation has been noted in Qazia Muhammad Muzammil versus State of Karnataka. The purpose of any probation is to ensure that before the employee attains the status of a...
No, my question is different. अगर आप probation discontinue कर रहे हो, you're not extending the probation period. Then whether it will amount to be dismissal, termination or what?
Now thereafter we have to see what the order was passed. The impugned order simply says termination. It does not refer the word dismissal.
No,
it does not refer the word.
That's why I want to know.
It would not be.
It's Bharat, that's why I want to know if the probation period is not extended, what will be treated? Whether it will be dismissal, termination or what?
It would be termination, simply stated termination because
where is the law?
Because what the rule says,
yes,
that the probation appointed for a period of 2 years on probation.
No.
The rule.
Which Bharat, the probation period is not extended.
Let me explain.
Yes.
For 2 years. The rule further says that after completion of 2 years, the candidate would not be automatically confirmed. The rule further says that the probation can be extended.
Yes.
And rule further says that until and unless that probation, a order of confirmation is not passed, it would be deemed to be on probation. Now, in this case, what has happened? The probation was extended for one time. And thereafter it was resolved not to continue with the probation.
Yes.
So the result would be.
So whether it has
the end result would be.
No, Mr. Bharat, whether the period has been extended for 1 year or for which period?
For a period of 1 year.
So whether in a period of 1 year, whether the subsequent order not to continue has been passed within 1 year or after 1 year? After completion of 1 year?
Yes.
When the order was passed on?
The order was passed on, the first order was passed. So, file 1.
ये है ना, हमने आपको दिया रिकॉर्ड, हमको वापस दे दीजिएगा.
नहीं, मैंने आपको वापस कर
वो नहीं वापस, ये हमारे पास अभी ये नीचे वाला रिकॉर्ड आपके पास
ये
है.
पहला ऑर्डर 18 मार्च 2016 को ऑर्डर हुआ. ये एक्सटेंशन का है. और उसके बाद जो है और जो दूसरा जो ऑर्डर हुआ, इसमें कोई टाइम स्पेसिफाई नहीं है. द पीरियड ऑफ प्रोबेशन ऑफ द फॉलोइंग प्रोबेशनरी सिविल जज ऑफ लोअर जुडिशियल सर्विसेज एज स्पेसिफाइड इन कॉलम 2 ऑफ द टेबल बिलो इज हियर बाय एक्सटेंडेड. बस वो 10 लोगों का दिखा है कि इनका एक्सटेंड किया गया. अब जो इम्प्यून्ड ऑर्डर है वो है एनेक्सर P1 9/2017 February 2017 एनेक्सर P1. और उस दिन सबका कंसीडर किया, पूरे 10 ऑफिसर का जिनका एक्सटेंड हुआ था. 9 को ओवरऑल परफॉर्मेंस ठीक था और कंप्लेंट्स नहीं है। डिस्ट्रिक्ट जज के जो इनकी रिपोर्टिंग अथॉरिटी है उसके कमेंट्स एडवर्स नहीं है।
हमको एक चीज थोड़ा और बताइए कि मिस्टर भारत की प्रोबेशन पीरियड का इफेक्ट क्या आएगा, वेदर इट विल बी टर्मिनेशन और डिसमिसल, सी नॉन एक्सटेंशन ऑफ प्रोबेशन पीरियड।
नॉन एक्सटेंशन रूल में 3 चीजें हैं।
हाँ
2 साल, जब तक एक्सटेंशन, और जब तक कंफर्मेशन नहीं होगा तब तक यू आर इन प्रोबेशन।
हाँ
नाउ इन हर केस व्हाट हैज हैपेंड, इट वाज एक्सटेंडेड
हाँ
and thereafter a decision was taken not to continue. So the two
what
orders,
will be its effect?
हाँ, वही
See,
बता रहा हूँ।
to fall within the ambit of
मैं
jurisdiction of 4C.
वही बता रहा हूँ। Non continuation of the probation
Yes.
there would be 2 type of orders. One dismissal and the other termination. Dismissal must be based on some misconduct.
We don't know.
नहीं
See, your rule, see, please, that's why I want to specific your judgment on this point.
let me develop it.
Yes, yes.
Dismissal must be based on some misconduct.
Yes. How is it necessary?
Because in the dismissal, Lordship, the candidate is precluded from getting employment in some other services. That is the basic difference between the dismissal and termination.
Please tell me the law. Please tell me as in law on this issue. Whether the probation, if it is not this.
ये महानदी कोल फील्ड्स में
बताइए तो महानदी वाले को।
कोई किताब निकाल दो ना। ये 2020 18 71 ये पहली बार कॉन्स्टिट्यूशनल बेंच ने आर्टिकल को कंसीडर किया था रामनाथ पिल्लई को।
And this Mahanadi has been referred from the against the gratuity rules.
हाँ gratuity rules
where the forfeiture of
recovery का है
forfeiture of amount of gratuity
yes.
under the Mahanadi coalfield. Where the in which paragraph the Honorable Supreme Court has said, see, my question is different. My question is with regard to probation, if he is not continued. See, my question is different, on a different footing. My question is whether the probation is not extended, what will be the effect? It will amount to termination or dismissal.
If the वही मैं बोल रहा था. If the probation is not extended, then 2 types of orders can be passed.
Yes.
First is termination and second is dismissal. Termination is simpliciter termination means that the candidate is entitled to वो है क्या कॉपी है क्या माने दी सकती termination simpliciter पिछली बार निकाले थे बाबू सर पिछली बार इसका प्रिंट would be that discontinuation. But if we pass an order of dismissal, then certainly 311 has to be complied with, as per the Ramnath Pillai's case. And even in this Rajasthan High Court's case also, if it is based on a misconduct, then 311 is
no,
accepted.
Mr. Bharat, my question is different.
I got, my lord's question is that if the probation is not extended, what would be its effect? Its effect is discontinuation of service. For discontinuation of service.
See, discontinued service means whether it will be termination or please bring any.
It would be based on the nature of order passed.
See, Mr. Bharat, you want to get rid of the rules of 4C. You want to say that the case of the petitioner does not fall within the ambit of Rule 4C of the standing committee rules. All right, but to get rid of the rules, you have to please bring the judgment. Whether the probation
judgment दे दूंगा मैं judgment ढूंढ लेता हूँ दे देता हूँ
yes
but what I am submitting non continuation of a probation the effect would be discontinuance of service. Now discontinuance can be of 2 types, a simpliciter discontinuance and a discontinuance with an allegation. Now in her case it is a simpliciter dismissal, so therefore it would be a termination. If it is a discontinuation is on the basis of some allegation, then it would be a dismissal on the basis of misconduct.
आप हमको और सर्च करके बता दीजिए कि प्रोबेशन को अगर एक्सटेंशन नहीं किया तो इट विल
कोई ऑर्डर तो पास करना पड़ेगा ना. नहीं
भाई हम आपका प्रोबेशन पीरियड नहीं कर रहे हैं, खत्म बात.
हाँ.
तो वेदर इट विल बी ट्रीटेड एज टर्मिनेशन और डिस्मिसल, व्हाट इज द बेसिक, दिस इज अ बेसिक इशू which require to be answered by this court while dealing with the contention raised by the petitioner or by the High Court, that the rules of force, she is saying that rule 4 is applicable, whereas you are saying that the case of the petitioner does not fall within the ambit of rule 4. So to decide this particular question,
इसको जजमेंट में देख लेता हूँ.
yes, please
देख लेता हूँ.
that is the
Non-continuation
that
of
issue will clear all the issues.
non-continuation of probation. What would
Yes,
it want?
yes, this is the basic issue which is
According to me, non-continuation of probation would be according to the order which has been passed. The order could be of two types: simpliciter or with an allegation.
See, this is the general phenomena, but
I will get it.
Since we have to, you have to come over the rules, and she is saying that it is fall within the rule 4. Therefore, termination, and as such, the standing committee has no role to play. This is the issue. This issue goes to the root cause of the case. If it answer is either in favor of the petitioner or the respondent, the whole exercise will be depend upon that finding only. Yes.
वो इशू पे नहीं, क्योंकि इसके पहले आपने क्वेश्चन किया था कि क्या वो किसी दूसरे जॉब के लिए एंटाइटल है या सेम सर्विस पे. दैट हैज बीन आंसर्ड इन 2022 13 SCC पेज 1.
2022
13 SCC पेज 1 has been answered.
What it says?
What it says: termination of service of the probationer without inquiry does not deprive him of any right to post, and hence it is not a punishment. But if instead of terminating his service without inquiry, employer chooses to hold inquiry into the alleged misconduct on inefficiency, termination of service is punitive because it puts stigma on his competence and he is entitled to protection under Article 311. और पहले वाले क्वेश्चन को आंसर किया है.
Yes.
और दूसरा वाला जो क्वेश्चन है कि अगर प्रोबेशन एक्सटेंड नहीं होगा तो क्या होगा, मैं देख लेता हूँ.
हाँ, वो बता दीजिए. यस, विल कंटिन्यू. कब करेंगे?
अभी भी आप.
यस, भारत साहब, आप मैडम, आप बताइए कब करना है.
सर जल्दी.
हाँ, हम तो सुन ही रहे, लगातार सुन रहे हैं आप.
अब बता दीजिए कोई तारीख.
यस,
नेक्स्ट वीक में कोई तारीख. मंडे ट्यूजडे छोड़ते हैं.
वेडनेसडे लगा दो.
हाँ, 14th आएगा.
14 फरवरी. ऑलराइट. आर्गुमेंट
एक दो सबमिशन था सर ने जो पॉइंट रेज,
वो आपको देंगे.
मेरे बाद आपको मिलेगा.
आप विल गिव अपॉर्चुनिटी टू मेक, विल गिव एम्पल अपॉर्चुनिटी टू मेक सबमिशन.
कर रहा हूँ उसको आप लिख लीजिए और उसके बाद फिर आप उसका
रिप्लाई दे दीजिएगा, कोई इशू नहीं. आर्गुमेंट कुड नॉट कंप्लीटेड, ऐसा लिखना. दिस कोर्ट पुट अ क्वेरी टू द लर्नेड काउंसिल फॉर द सीनियर काउंसिल टू ऑफ द हाई कोर्ट whether if the probation period is not extended, will it fall within the ambit of dismissal or termination. Let the senior counsel may make submission on this issue. List this case on 14th February. Immediately in the list of fresh matter list. Fresh matter list में कर देते हैं, सुन लेंगे उस दिन कंप्लीट कर लेंगे.
रिकॉर्ड्स आप रखेंगे?
ये रख लो आप, रिकॉर्ड आपको रखना.
फाइल